This section projects how jury nullification might evolve in an era of shifting legal norms, growing civic awareness, and rapid technological change. It opens by examining proposals to modify jury instructions, aiming to balance clarity and respect for moral agency. Next, it considers legislative possibilities, such as narrowing mandatory sentences or allowing limited jury discretion, which could reduce tensions, prompting nullification. The section then addresses enhanced jury education and community engagement, highlighting ways informed citizens might responsibly exert conscience-based decisions. Finally, it explores how digital activism and emerging technologies could alter both jury selection and the broader public dialogue on justice. Reform proposals. In the chapters leading up to this point, we have traced jury nullification through its historical origins, examined its modern-day applications and controversies, and considered its deeper social ramifications, especially for marginalized communities. We now turn our attention to the future and explore a range of reform proposals aimed at striking a more thoughtful balance between the formal rule of law and the moral dimensions of justice that conscientious acquittals sometimes highlight. While no single policy or practice can fully resolve the tensions inherent in nullification, these proposals invite us to imagine a legal landscape where the jury's moral voice is neither suppressed nor allowed to derail equitable enforcement. Revising jury instructions. One of the most widely discussed reforms involves adjusting or enhancing the instructions judges provide to jurors. Presently, many jurisdictions offer standard templates that emphasize the duty to apply the law as explained by the court, leaving little room for jurors to even consider the moral implications of their verdict. However, reform advocates suggest that transparency is preferable to leaving conscientious acquittals in a gray area. Explicit acknowledgement of conscience. Some proposals call for a brief instruction informing jurors they may consider both fact and fairness in arriving at a verdict. While this would not openly endorse nullification, it would legitimize the idea that jurors can weigh a defendant's individual circumstances or the perceived injustice of a statute. Critics fear such an instruction might open the floodgates to arbitrary or biased decisions, but supporters argue that open acknowledgement prevents the ethical confusion many jurors face when they intuitively sense an injustice. Cautionary language. Other approaches aim for a middle ground, proposing that jury instructions include a cautionary note on the rarity and gravity of nullification. Jurors would be reminded that disregarding the law is an extraordinary measure meant only for cases where applying the statute would produce a manifest injustice. Such language seeks to guide moral judgment while discouraging frivolous or discriminatory acquittals. Whether adopting explicit or cautionary instructions, reformers maintain that clarity benefits both jurors and defendants. A transparent approach could demystify the power jurors already hold, mitigating misunderstandings and reducing potential abuses. Sentencing flexibility. Another cluster of reform proposals focuses on alleviating the very conditions that often prompt conscientious acquittals. Draconian sentencing guidelines. When mandatory minimums lock judges into handing down long prison terms for relatively minor crimes, jurors may be moved to acquit solely to avoid condemning a defendant to a disproportionate fate. Reducing or eliminating mandatory minimums by allowing judges greater discretion. The criminal justice system may better differentiate between high-level offenders and those caught in low-level or nonviolent infractions. This diminished severity could lower the moral stakes for jurors. If they trust the court to issue a proportionate penalty, they may feel less pressure to nullify. Expanding alternatives to incarceration. Drug courts, diversion programs, and restorative justice processes offer creative pathways that bypass the binary choice between conviction and harsh punishment. In systems where such alternatives are well established, jurors tend to see the law as more fair, reducing the sense that an acquittal is the only remedy for what they believe to be an unjust system. Reforms along these lines not only address jury nullification concerns, but also dovetail with broader movements seeking to reduce mass incarceration and promote rehabilitative justice. If the criminal justice system is perceived as fair and balanced, nullification, while still available, might become increasingly rare. Enhanced jury education. A third set of proposals revolves around better preparing citizens for jury service. Often, prospective jurors learn about the criminal process, evidentiary rules, and their duties only after they arrive at the courthouse. Reforms could improve this by integrating comprehensive civic education into school curricula and community programs. Pre-service orientation courts could provide online modules or community workshops explaining everything from how a trial unfolds to the range of sentencing options, ensuring potential jurors grasp both the law's requirements and the moral intricacies that sometimes arise. An orientation might emphasize the jury's key role in applying the law, while acknowledging the rare but recognized power of nullification. Community-based civic engagement grassroots efforts, led by nonprofits, legal aid organizations, or universities, can deepen public knowledge long before individuals are called for duty. By fostering open dialogues about systemic inequities, the societal cost of incarceration, and the ethical dimensions of criminal law, these programs help citizens approach jury service with a more nuanced understanding. This broader context can mitigate sudden moral shocks during trials and encourage more thoughtful deliberations. Through education, reformers hope to replace confusion or fear with informed reflection, minimizing the risk that jurors will nullify out of raw emotion or bias while still respecting their ultimate moral agency. Legislative adjustments to nullification procedures. Some reformers advocate legislative changes that would specifically address or codify aspects of nullification, rather than leaving it as an unspoken, judge-disfavored possibility. These proposals aim to define the boundaries within which conscientious acquittals may occur. Limited nullification statutes. Few state legislatures have considered bills that would permit a narrow nullification defense. Under such statutes, defendants could argue certain extreme facts, such as entrapment or unconscionably disproportionate penalties, merit an acquittal despite technical guilt. While these proposals rarely pass, they reflect an impulse to channel moral considerations into a regulated framework, reducing unpredictability while affirming that some laws warrant flexible enforcement. Transparency requirements at the extreme end of reform. Some propose requiring judges to inform jurors that no legal repercussions follow a not guilty verdict, effectively encouraging them to consider their conscience without fear. Others push back, contending that such transparency might undercut the seriousness of criminal proceedings and yield inconsistent outcomes. Ultimately, legislative adjustments remain controversial, as courts often resist direct intrusion into jury deliberations. Still, the fact that these ideas persist indicates a growing awareness of nullification's consequences and the desire to shape them more constructively. Technological considerations and social media. Modern technology amplifies all aspects of the justice system, and jury nullification is no exception. Rapid information exchange can educate or misinform citizens about their power to nullify, while social media campaigns may raise public sympathy for certain defendants or highlight perceived injustices. Reforms addressing these challenges typically seek to preserve fair trials while acknowledging the unpreventable reality of instant, pervasive communication. Stricter judicial orders. Many courts have tightened rules against jurors researching cases online. Yet these instructions can be difficult to enforce in a world where social media is ubiquitous. New reforms might involve more rigorous vetting of jurors' online activity or advanced monitoring, which raises its own civil liberty concerns. Proactive court communication. Courts are beginning to experiment with transparent, official communications, such as public-facing websites or social media channels, clarifying how trials work, what jury nullification is and is not, and why it should be treated as an extraordinary measure. By controlling at least some of the narrative, courts aim to offset the swirl of online rumors or partial truths. While digital dynamics are relatively new to the legal realm, they already shape the context in which nullification occurs. Carefully crafted reforms can mitigate confusion without censoring legitimate discussions about the moral dimensions of law, balancing law, morality, and social progress. Beneath all these reforms lies a shared objective: to harmonize the need for consistent legal application with the recognition that law must remain responsive to evolving moral standards. When the two align neatly, conscientious acquittals become seldom necessary. When they diverge sharply, nullification emerges as a vivid expression of public dissent. Collective ownership of the legal system reform proposals are successful only insofar as they engage the broader community. Legislators, judges, civic groups, and everyday citizens must all grapple with the question: under what circumstances should jurors disregard the law? By posing this query openly, society can better refine statutes to lessen the impetus for nullification while preserving its essential safeguard against tyrannical or outmoded legislation. Ongoing dialogue. Ultimately, these reforms are neither monolithic nor final. As social values shift and technology evolves, new challenges will arise. The task at hand is to create structures flexible enough to accommodate moral progress, yet robust enough to maintain a coherent legal framework. Incremental changes in jury instructions, sentencing approaches, and public education may yield a criminal justice environment where nullification is recognized as an extreme, but occasionally necessary measure, rather than a taboo or a reflexive reaction to perceived injustice. In envisioning these future directions for jury nullification, we see that the path forward is multifaceted. Policymakers can experiment with more transparent jury instructions or targeted legislative reforms. Advocates can educate communities to promote informed moral reasoning, and technological tools can either hamper or help these reforms, depending on how they are deployed. Yet the central tension between law's requirement for uniform enforcement and the moral convictions of individual jurors will likely persist. The reforms outlined here do not promise to eliminate that tension, but rather to guide it toward more constructive and equitable ends. In the final portion of this book, we will consolidate the lessons gleaned from history, theory, and practice, reflecting on how a balanced and ethically guided form of jury nullification may serve as both a testament to democratic values and a necessary break against injustice. By synthesizing the insights from each section, we can arrive at a clearer, more nuanced understanding of how conscientious acquittals fit into the broader tapestry of legal evolution and social conscience. Technological influences. In the previous chapter, we explored various reform proposals aimed at harmonizing jury nullification with a consistent and fair application of law, from revised jury instructions to sentencing flexibility. Now we turn our attention to the rapidly shifting landscape of technology and its potential to reshape how juries are selected, informed, and influenced. While the core tension between legal mandates and moral conscience remains unchanged, modern tools, from social media platforms to data-driven analytics, introduce new challenges and opportunities for those concerned with maintaining the integrity of trials. By examining these emerging technological influences, we glimpse the future of jury trials, including how jury nullification might evolve or be constrained in a hyper-connected world. Social media and public perception. One of the most significant technological forces impacting jury trials is social media. As platforms like Facebook, Twitter, Instagram, TikTok, and discussion forums proliferate, the boundary between public opinion and juror neutrality grows increasingly porous. Instant information and misinformation. Whereas traditional news cycles once took days to disseminate a trial's details, contemporary social media can amplify a story within minutes, sometimes providing partial or misleading accounts. Jurors who stumble upon these discussions, intentionally or not, risk absorbing emotional or factually inaccurate narratives that paint the defendant in a certain light. Moreover, high-profile advocacy campaigns can ignite widespread sympathy or outrage, urging jurors to deliver a verdict aligned with collective sentiment rather than the law or the evidence. Civic awareness and jury nullification discussions beyond misinformation. Social media also fosters robust civic conversations that might broaden public knowledge of jury nullification itself. Activist groups and independent legal educators may post about the history of conscientious acquittals or share guidelines on how jurors can engage their moral compass when deliberating. Some activists see this as a democratizing tool. Finally, knowledge about nullification is no longer confined to legal insiders. Others worry that sensational posts may oversimplify or outright encourage ignoring the law, introducing new avenues for bias. Court-imposed limitations. Many courts already instruct jurors not to research or discuss their cases online, but enforcing such bans is notoriously difficult. Future reforms could involve stricter penalties for jurors who violate these instructions. Yet even this approach may be overly punitive and challenging to detect. Balancing the educational potential of social media with the need for trial integrity remains a difficult conundrum, one that legal professionals will continue to grapple with as technology evolves. Digital justice ecosystems, virtual courtrooms, and remote proceedings. The technological shifts accelerated by global events, such as the adoption of remote and virtual court proceedings, open another dimension for studying jury nullification's future. Video conferencing and virtual juries. Several jurisdictions have explored or implemented remote jury selection and even partially virtual trials, especially during public health crises. While these innovations expand access to justice and reduce certain logistical barriers, they also change the dynamics of jury deliberation. Discussions mediated by screen can lack the subtle interpersonal cues that arise in a physical jury room. Jurors may be less prone to forging a sense of collective conscience, which could dampen the inclination to push for nullification if they sense a law is unjust. Conversely, remote settings can free some jurors to express dissent without the physical pressure of a face-to-face environment, potentially encouraging more independent thinking. Technological barriers to confidentiality in virtual settings. Ensuring confidential deliberation becomes more complicated. Private chat messages, screen captures, or unauthorized recordings pose risks. If confidential dialogue among jurors leaks, external advocates or commentators might attempt to sway them mid-deliberation, a scenario that could magnify nullification if certain groups pressure jurors with moral or political arguments. Courts must develop robust cybersecurity protocols to protect the sanctity of deliberations, as any breach could undermine trust in the verdict's impartiality. Access and equity. While technology can streamline trials, it can also exacerbate inequalities. Jurors who lack reliable internet access or familiarity with digital platforms may be excluded or disadvantaged. Meanwhile, attorneys adept at using virtual presentation tools might influence remote juries more effectively than those less technologically savvy. Addressing these disparities is vital for a fair, equitable justice system, particularly relevant to conscientious acquittals, which hinge on nuanced moral understanding that shouldn't be drowned out by digital imbalances. Jury selection and artificial intelligence. From large-scale data analytics to algorithmic screening, artificial intelligence, AI, is poised to transform how attorneys and courts handle voir dire, the process of selecting jurors. These developments have major implications for any potential nullification, as who ends up on the jury significantly affects verdict outcomes. Algorithmic profiling of jurors. Companies already market predictive tools that promise to profile potential jurors based on social media footprints, voting records, consumer habits, and more. The hope, from an attorney's perspective, is to identify which individuals are most likely to be sympathetic or hostile to a particular case. While such profiling is arguably an extension of traditional jury consulting, AI can sort through vast troves of personal data far more rapidly and comprehensively, raising privacy concerns and questions about fairness. Nullification hotspots. One speculative outcome is the identification of nullification hotspots, neighborhoods or demographic segments with a higher probability of acquitting out of moral disagreement. Prosecutors might then try to eliminate or reduce the influence of jurors from those backgrounds, while defense teams might prioritize them. This arms race could deepen existing societal divides. Some jurisdictions may consider tighter rules on juror privacy or limitations on the use of big data analytics in voir dire to safeguard the jury's integrity. Ethical considerations. Deploying AI in jury selection touches on the core ethical question of whether data-driven elimination of problematic jurors erodes the representativeness of the jury. If the aim is to systematically weed out individuals likely to question or defy harsh laws, then the possibility of conscientious acquittals might be curtailed. Striking a balance between allowing reasoned peremptory challenges and protecting diverse perspectives is a debate that will only intensify as AI technology becomes more refined. Data-driven verdict predictions. In addition to aiding jury selection, AI-driven tools are emerging that claim to predict trial outcomes. By analyzing prior cases, sentencing records, and judge/jury decisions, these tools purport to estimate the probability of conviction or acquittal. While such systems might offer insights for plea bargaining or settlement discussions, they also risk commodifying the trial process in ways that overshadow moral deliberation. Automating the moral X factor, no dataset can fully capture the unpredictable element of conscience in a jury trial. Nullification, by definition, arises when jurors opt for a verdict that goes against expectations. Nevertheless, if attorneys rely too heavily on predictive models, they may disregard intangible factors, like empathy for the defendant, cultural shifts, or local controversies, that could drive jurors to nullify. Over-reliance on data might dull the readiness of legal professionals to recognize when a case's moral stakes warrant special attention or a more nuanced approach. Recalibrating legal strategy. If attorneys come to believe that nullification is improbable, they might pursue standard arguments without addressing deeper moral issues. Conversely, if the model flags a high chance of conscientious acquittal, the prosecution might respond with harsher narratives or plea deals aimed at avoiding a public trial. The net effect could be a system where intangible human values are either amplified or suppressed based on algorithmic likelihoods, potentially distorting how justice is both sought and administered. Technological tools for civic education. While many technological influences present challenges, they also offer new avenues for enhancing civic awareness and reducing the risk of manipulative or prejudiced juror decisions. Nonprofit organizations, educational institutions, and community groups can harness digital platforms to provide balanced, accessible information about the legal system, the function of juries, and the complexities of nullification. Interactive learning platforms, web-based simulations can walk citizens through hypothetical trials, highlighting points at which moral questions might arise. By encouraging prospective jurors to weigh different factors, evidence, the letter of the law, proportional punishment, these tools can demystify trial procedures and underscore that moral reasoning need not be an afterthought. Tailored community outreach. Social media can be harnessed for positive ends, too. Well-designed campaigns can circulate fact-check material on the historical legacy of nullification, the perils of using it for biased ends, and the appropriate time and place for conscientious acquittals. Such educational efforts may reduce knee-jerk reactions or sensational misunderstandings, fostering a more deliberate brand of civic engagement. Balancing innovation with fairness. From social media's cultural impact to AI's predictive prowess, technological innovations promise to reshape the contours of jury nullification. In some respects, these developments bolster transparency, inviting broader public debate and knowledge sharing about conscientious acquittals. At the same time, they risk intensifying biases, undermining confidentiality, or constraining the jury's moral freedom. A nuanced approach that respects fundamental legal principles and fosters informed public participation is crucial. Robust ethical guidelines. Courts, bar associations, and legislators can craft guidelines governing AI-powered jury selection, data usage, and juror privacy. Transparency in remote trials. Virtual proceedings must be coupled with clear norms on digital communication, ensuring deliberations remain confidential and free from outside manipulation. Collaborative education. Policymakers, educators, and activists can combine efforts to create widespread programs that clarify both the powers and perils of nullification in a technological age. Technological influences stand at the frontier of jury nullification's evolution. Social media discourse can reshape public perceptions overnight. AI tools can alter the very composition of juries, and virtual court processes can recast how deliberations occur. Each of these innovations, for better or worse, touches upon the tension between law's uniformity and the jury's moral prerogative. In the final segment of this book, we will synthesize the central themes from our historical, legal, ethical, and socio-political explorations, proposing a cohesive framework for understanding jury nullification as a living, adaptive feature of democratic justice. By integrating both the cautionary lessons of history and the transformative possibilities of emerging technology, we can strive toward a system where conscientious acquittals remain an extraordinary, but principled, response to law's occasional misalignment with conscience.